Morning, judges. If I may, I'd like to reserve 10 minutes for a vote. May it please the court, my name is John Geekus from Saul Ewing. I represent the appellants, MV Realty, Tony Mitchell, who's here in the courtroom today, David Manchester, and Amanda Zachman. We raised obviously quite a few issues in our briefing, but I'd like to begin by focusing on and expanding on the point that we made at the beginning of our reply brief, which at least for me, I think is the crux of the issue. The crux of the appeal, which is that just because the Office of Attorney General alleges something to be true or alleges facts does not make them true. There is an established process for deciding what facts are more probably true than not. And obviously that process is a trial, which is what we were improperly denied in this case. If you review the circuit court's opinion, particularly, for example, its ruling on unconscionability in paragraphs 9, 10, and 11, there's one conclusory statement after another with no citation to any evidence.
You're talking about 9, 10 summary judgment order.
I am, yes, which is the basis for the permanent injunction and was incorporated into the permanent injunction.
Well, it is incorporated, but whether it's the basis, I think is part of what we are here to talk about today, isn't it?
Well, if you say it is, Judge. I would say I don't think there is any fair debate that it is the basis of the opinion. If you look,
well, we had a 4-day hearing with the transcript and then boatload of exhibits. I think you gave us 40,000 pages, an appendix here. And so there is a pool of evidence that I think is common to both the injunction and the summary judgment. Do you disagree with that?
Well, I think there is a pool of evidence, but I would classify the evidentiary record from the preliminary injunction hearing as legally no different than the discovery record that would exist in a case on summary judgment where there was no such hearing, deposition transcripts and the like. The circuit court's opinion on the permanent injunction does not reference or cite to the evidentiary record from the preliminary injunction, the temporary injunction hearing. It's quite specific that it's based on the
well, I don't want to state about this, but their moving paper on the injunction also is largely rooted in the summary judgment findings as opposed to full of evidence. So you have something to talk about that, but my question for you is, as a practical matter, there is a pool of evidence, and whether you classify it as summary judgment evidence or discovery evidence, the way you described it, or just conventional evidence because people were put under oath and authenticated exhibits and the trial court reviewed them as they would in another bench finding proceeding. We agree that there is a common pool of something resembling evidence regardless of your description, don't we?
I agree that there is that evidence, Your Honor, and what I would say is that at the summary judgment stage, the circuit court was required to construe that evidence in the light most favorable to the non-movement, particularly where it related to issues that the judge was not the finder of fact on. It would have been for a jury.
In summary, I don't disagree with you about, and I'm here to talk about the summary judgment standard today, but what's your view of the standard review for findings on the injunction?
I think it is de novo, Judge.
Even in fact findings, we don't review.
Well, we're not
on evidence.
I do. I think the entire scope review is de novo. I think there were legal issues made, including, and I recognize it sometimes gets merges into arguing about the evidence itself, but including the legal issue of whether summary judgment was appropriate is itself a legal issue, which is reviewed de novo, as well as whether the evidence was sufficient to warrant the entry of a permanent injunction and the scope of that injunction. I believe those are all reviewed by this court de novo. So in addition to the resolution of disputed facts, there are obviously a number of important legal issues. I think the most important one being the application of FDUPA's safe harbor in 501(2)(12). The ability to file, indeed the right to file a memorandum of agreement is something that's been recognized by this court in the City of Largo case that we cited in our briefs, as well as in the statutory framework. There was no dispute in the record below that the county clerks, who are the constitutional officers under the Florida Constitution, are the officers responsible for reviewing and recording those instruments. And indeed, the evidence was undisputed that when they do that, they make their own assessment of how to categorize the document.
I think an assessment as to how to categorize it and whether or not it meets the requirements to record it.
Correct.
They don't do an independent assessment as to whether or not the document was legal, whether it's legally enforceable, whether it was obtained by fraud, whether it was fully arm's length. They don't do that, correct?
Correct, but those underlying issues would all be disputed facts, Judge. It would not be, so
But you hang, at least in part, you hang your hat on this idea that there's a safe harbor. It seems to me that is only to the extent was the document properly recorded based on the recording requirements and the context of the document. I mean, beyond that, the question is one of factual determination, whether or not there was fraud in the inducement, whether people understood what they were getting and so forth. Clerk's office doesn't look at that.
So I think I agree with what you just said, Judge, if I may just recast a little bit in my own language to make sure. If the document is recorded legally, for example, in the absence of fraud or duress, then the safe harbor applies. On the other hand, there is then a factual.
How far do you take the safe harbor provision? I mean, it seems to me your argument in your briefing was this case is over because it was properly recorded and accepted by the clerk's office. That sounded like what you were arguing in the safe harbor argument.
Well, I think that's right, but at a minimum, I would say that if there is a dispute about whether the documents, the memorandum, or the right to file the memorandum was illegally obtained, for example, by fraud, that would be a factual dispute. I mean, for example, one of the undisputed facts.
Might have been resolved by the facts of record or might not have been resolved by the facts of record.
Why? I think it would be for a finder of fact, because, for example, one fact that was undisputed was the fact that MV had the right and would file a memorandum was fully disclosed. Each consumer signed and notarized the memorandum itself at the same time they executed their HBA. So there can be no argument, no genuine dispute of material fact that the consumers were all aware and it was disclosed that they'd be filing the memorandum. What the Attorney General's office argues is that consumers didn't understand the effect of that instrument. Setting aside the fact.
Your position is that the consumers were misled as to what those documents purportedly did.
Well, I think that I think
So that's their argument. Whether they're right or wrong is not something you and I are going to debate, but that's ultimately the foundation of our decision will be, at least in my mind, is there sufficient evidence to support the trial court's legal conclusions warning the injunction?
Well, and on that point, Your Honor, those are disputed facts that whether or not consumers were misled. Indeed, one of perhaps, I would say the most hotly disputed fact in the case is what the effect of the memorandum actually was. The Attorney General has time and again said that it blocks people from filing liens, but as we pointed out, they admitted that there's not a single memorandum recorded anywhere in all 67 counties in Florida that was ever classified as a lien. We asserted an interrogatory that asked them to specify. I'm sorry.
It's just a kind of.
I don't know if I would say just, but it is included. That is one of the terms that's included in the HBA.
Perhaps even, it's at least as strong as lien. Would you agree?
I would not agree because for example, among other things, the filing of the memorandum does not give priority rights to later filed instruments. So it's not like a lien at all, I would say, Your Honor. I think the only thing it does is provide notice of the agreement, and that's why time and again in our submission, 93% of the time, consumers are able to refinance their homes without even contacting MP. Of that remaining 7%, nearly every instance, consumers were able to refinance with minimal assistance that MV provided free of charge, either in the form of a subordination agreement, if that's what the lender required, even though we didn't think one was necessary, or what we would call a lift and replace, where MV would terminate the memorandum, allow the refinancing transaction to close, and then refile the memorandum. And even in the consumers' cases that they specifically identify as evidencing their, the harm that they allege, they actually does not support their own case. And so, for example, and these are all names.
Wade into other facts. I want to make sure that I understand where everybody is and what we're due the realm. In this context, typically an injunction requires adequate legal remedy, showing no adequate for requirements, no adequate legal remedy, no harm, blah, 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 right? Here, all the trial court had to find, because of the statutory context that we're in, and the enforcement powers of the Attorney General, was a clear legal right to the injunctive relief. Do you agree with that?
I'm not sure I would have, I think that would be the standard for the temporary injunction, Judge. I'm not sure that would be
Well-
a permanent injunction.
So if that's not the standard for a permanent injunction, what is the standard?
Well, I,
What else do they have to, what else does is the Attorney General have to do? Besides a clear legal right? To be entitled to a permanent injunction.
I think they also have to establish the necessary scope to prevent the,
So narrowly tailored findings and.
Correct.
And narrowly tailored relief, but in terms of the affirmative burden, what elements do they have to prove to get a permanent injunction? Do you agree that clear legal right of the, four enumerated elements, clear legal right is the only one that was in play here?
yeah, well, that, yeah, in the scope of the injunction, correct.
Okay, which is different than the burden. That's what the trial court is
Yes.
charged with taking care of, making the right findings, making it narrowly tailored. But as far as what their burden was, it was a clear legal right. And all of your merits arguments presumably go to the existence or non-existence of that right. Do you agree with that?
Yes,
I just wanted to make sure I was.
yes. No, and I apologize. I misunderstood earlier.
Got you 10 minutes.
Thank you.
May it please the court. Good morning, Your Honors. My name is Ellen Lyons. I'm special counsel with the Office of the Attorney General, State of Florida. The proper question before the court today is whether the injunction order that was entered on February 12th, 2025 meets the requirements of Florida Rule of Civil Procedure 1.610C. The injunction is born out of the state of Florida's litigation against Appellants MV Realty and its principals, Amanda Zachman, Anthony Mitchell, and David Manchester. Appellants would have you believe that the Office of the Attorney General arbitrarily took aim at a perfectly legitimate company that gave money to consumers and
Let's talk
clients.
about what we're protesting on this appeal.
Yes.
Okay. Let's look at this injunction order and let's take out the last sentence in paragraph 3, the
Okay.
order on appeal, where it says the court hereby fully adopts all findings. That's getting conclusions of law from the summary judgment order.
I'm sorry, Your Honor, I'm not with you. The last
I'm
paragraph,
looking at the order on appeal.
yes,
We're looking at the last sentence in paragraph 3.
yes.
The court hereby fully adopts all findings of fact and conclusions of law set forth in the summary judgment order.
Yes, Your Honor.
If we take that out of this summary judgment order, which is what we're reviewing, then we are left with, 3 pages of paragraphs and the actual injunctive provisions, right? But the question then becomes, is this order, are the findings legally sufficient without that sentence
Yes,
to support the injunctive relief?
yes,
And the question is how? Because the second, look, we know how easy it was to put it, or how hard, I'm not the person that had to write the order, but somebody put together a big giant summary judgment order that cites 2 voluminous places in the record. That's what you're relying on, and it's based on things that came out of that hearing and all the exhibits and material that were in the record up to the date of the summary judgment. You then file a motion for injunctive relief and tie it almost exclusively to that order, when it would have been just as easy to cite the same evidence that the order cited to, just like it would have been just as easy to have this partial summary judgment on injunctive relief, instead of incorporating, just reciting. So I guess the simple way to ask this question, and I'm sorry for the run-on, if this order had, if it incorporated, instead of incorporating, if it included in the body of the order, the bulk of the findings, the operative findings, would we have anything to talk about today?
that's a good question, Your Honor. Really, Rule 1.160 really just requires a reasonable basis, a reasonable fact basis for the entry of the order, and
Does
then,
it require findings? I mean, at least as it's been interpreted.
Does it require findings? I think the court does make findings.
Well, so, again, and this is where I think the gist of what we can do here and what we're looking at comes out. If we take the incorporation out, and the proponent would agree with me, there's a straight face argument to be made as to these findings, that they are very conclusory. Particularly when we look at the depth of the findings in the summary judgment.
You're saying because there are no citations within
No, I'm
the,
saying because there aren't any findings. If we take the incorporated findings out, what we have boils down to conclusions of law. Based on
Actually-
evidence that there's a good argument we can't look at.
no, Your Honor, it actually is very clear. It says between 2018 and November of 2022, defendants executed approximately 9,303.
I can read it, I have, right?
Yeah.
But these are very conclusory summary type statements that I think are type, that are based on.
Well, I think they're the essence of the complaint, Your Honor. The essence of the case is these contracts got entered into, they contain a covenant running with the land. People couldn't possibly know what that means. And anybody who read this agreement could not have figured out that a memorandum that was going to encumber their property was going to be filed on their property within 48 hours. You could never,
I'm not sure I can agree with that.
yeah?
Because doesn't that depend on the sophistication of an individual?
We are an enforcing authority, Your Honor, and so those ideas about individual, or in a class, you would look at individual injuries. Here, we're the enforcing authority, and it's a consumer acting reasonably under the circumstances.
I understand what this action is.
Yeah.
But are you telling me that if you were presented with this kind of memorandum, you would have no clue what it means?
I would have a very difficult time understanding what it means. In fact, I spent,
Well, I'm not that much smarter than you perhaps, but I can read the agreement.
so
And
you,
it seems relatively straightforward for someone who is moderately sophisticated with business dealings.
it does not say encumber. It does not say
It
what.
says it will be a covenant running with the land.
Mhm.
That seems to me to be something when you do a real estate deal, if you have a broker or you have a closing agent and you're talking about these things, I'm not sure I can agree with you that nobody would understand.
Actually, we had
It's a covenant.
Yes, Your Honor, we had expert testimony. This is really a finding of fact of the trial court. And the expert testimony by both our title expert and our real estate expert was that title companies treat covenants running with the land as encumbrances, and that regular consumers of real estate would not understand that the memorandum created an encumbrance. What?
Regular consumers.
Yes, and the appellants
That
brought,
does not give credence though to the possibility that some of these consumers were sophisticated buyers.
yeah, and we do enforcement actions, Your Honor. And so we're looking at the reasonable, consumer acting reasonably under the circumstances.
So under a situation like this,
Mhm.
something that might be analogous, even if there might be some very sophisticated consumers who like the deal, want the deal, understand the deal, your position is it would still be fully unenforceable even as to them.
Absolutely, Your Honor. It's enforceable as to every single consumer.
What your position was.
Right. And what we do, we are the enforcing
I
authority.
think we understand
What you're saying is this is not a class action.
It's not a class action, Your Honor.
This is not a suit for,
Damages.
Damages,
Right.
what happened, somebody's been defrauded. This is an enforcement action by the state.
Right. It's an enforcement action by the state seeking equitable relief. The type of relief that we seek is for
And why
equity.
don't we have a final judge?
That's a great question, Your Honor. The partial summary judgment did not reach the question of willfulness, which is the penalty piece.
So
And,
you want money too.
oh, we want, yes, there will be penalties. Those are considered a type of equitable relief.
I started with what exactly remains in the way of judicial labor here.
Correct. It just needs
Penalties.
a determination on penalties and then a,
Let me ask you a question back to what I'm hung up on, which is this injunction order and that we're reviewing.
Mhm.
One of the findings, and this is at the beginning of paragraph 4, is the HBA's and associated memoranda are procedurally and substantively unconscionable and thereby. First of all, I think that's the meat of what's at the bottom of the enforcement, right? So substantively and procedurally unconscionable. And, you know, the body of law is procedural and substantive unconscionability. And you, I assume, would agree with me that the unconscionability analysis is factually driven, at least insofar as procedural unconscionability.
Yes, Your Honor.
And so where is, if we take that sentence out of paragraph 3, where is the fact finding that supports procedurally and substantively unconscionable in this order?
Yes. It is where the HBA includes a provision whereby consumers are required to acknowledge.
You're entirely wrapped up in paragraph 3.
I'm so sorry, what?
You're relying entirely on the statements in paragraph 3 that precede the incorporation.
Well, and I was also going to cite to paragraph 4, where the defendants were directly involved in planning, engineering, implementing, and execution of the key aspects of the HBA and the memoranda.
Judge LeBret and you have concentrated on the injunction order itself.
Yes.
And the question is whether, you know, that you propose is, can you look back to the summary judgment?
Yes, Your Honor. Now that I thought was the crux of the appeal.
Well, it's from your perspective, it is. From the other side's perspective, it's a given. But
Right.
By looking at the summary judgment order, it finds that, you know, plaintiffs entitled to partial summary judgment as to liability and injunctive relief.
Mhm.
And at the foot of that order, well, I'm scrolling here. The court orders that the motion for summary judgment in part as to liability and injunctive relief is granted as to the company and the individuals. And it says that the status conference, the upcoming status conference, the upcoming
Yes, we were going to have a case management
status
conference.
conference, at which time the court will consider, among other things, the scope of the injunctive relief.
Yes.
Why don't then the findings and evidence that support theoretically the findings in the summary judgment motion carry forward to the injunction itself?
In the drafting?
Or why can't we, when reviewing the injunction, look at the summary judgment?
Yes, are you talking about jurisdiction or standard of review?
Kind of both.
Okay, all right. So with regard to jurisdiction, the argument that they're making, that the appellants have been making, is that you can vacate the summary judgment order, all right? And in our summary judgment and in our complaint, we seek equitable relief. In the summary judgment order, we seek equitable relief. So this is different from a regular case where people are looking for something a little bit different. And so we sought those things. It was requested in the summary judgment order, and we were going to get a injunction. The form of the injunction was going to be decided after that. But then the appellants filed an appeal that was deemed premature by this court. And so it was actually 4 months later that we actually got to the injunction language itself, Your Honor.
Okay.
And in that time, appellants continued to enforce their unenforceable contracts. And so that's why we had to have the relief that we did. By that time, 4 months had passed. We worked towards a order. We submitted something substantially longer to the court. We asked for a lot more relief, and the court didn't give it. The court was very clear about here's the factual basis, and here is the terms, and it was narrowly tailored to the harm. And thus, you know, to the extent that this order meets those requirements, you should affirm. But what they're trying to do is take this Rivercrest decision, and it's a case really about standard of review, and they're trying to say that this court can vacate the summary judgment while it vacates the injunction. We don't believe that, okay? There is a hybrid standard of review by virtue of that sentence being in this order, that sentence that says, fully incorporates or fully adds the, so they reference each other, right? Okay, Your Honor, and it does create a hybrid standard of review where you are going to be looking for competent substantial evidence to support the injunction, and you're going to be looking at the summary judgment findings to the extent that they are necessary for the injunction. You're going to be looking at those on an abuse of discretion standard. But there's parts of the summary judgment that don't relate to the injunction at all, like the telemarketing violations. They did a lot of spoofing, which is spoofing local numbers where they would call people and the phone number that they were calling from would be spoofed on caller ID. They did a lot of pre-recorded voicemails without consent. They did calls to the DNC, and the judge found all of those things to exist in the summary judgment as well. Now, those didn't get addressed in this injunction, and therefore they're not capable of review of any kind on this appeal. Really, Your Honor, the jurisdiction needs to be limited to the injunctive language of the injunctive order.
Well,
But this,
that was sort of where I got to.
Right.
Asking questions about, let's take out this sentence.
Mhm.
What provisions, you both talk about like reviewing the injunctive provisions, and the cases talk about this too.
Yeah.
What is, in your view of it, what are the injunctive provisions in the order that's on review?
okay, they're very easy, Your Honor. They're just 5 types of prohibited actions.
So we would only look under this.
That's correct. You want to look at those and you're going to say, look, is there some reasonable relationship? The FTC versus Palmolive case says, if there's no reasonable relationship between the acts, the harm, and the acts to be enjoined, then that's when the injunction should be disturbed. That's when it should be reversed. But here we say to, the judge says to MV Realty and to the appellants, stop enforcing the unconscionable and unenforceable agreements. Okay, that's the number one thing. Stop telling title agents, real estate brokers, and other people that you have enforceable monetary rights in other people's property titles. Okay, that's the second thing. And then stop representing to consumers that we're telling consumers that they have to use MV as a realtor or that they have to pay early terminations fees of 3% of the value of their home. Then the court also says to appellants, record memoranda of termination. Okay, because the memoranda has always acted as an encumbrance. And it's interesting because appellants are going to say there's no evidence that anybody treated this as a lien. The evidence is appellants' own documents that say
It doesn't have to be a lien.
it doesn't have to be a lien. We're saying that it acts like a lien, right? We've never, that's not true. We're saying that the way that it works is the HBA talks about an obligation. It creates an early termination fee of 3% of the value of your home. And that goes beyond what you might consider a sale. It's foreclosure. It's any type of transfer of title without MV getting paid. Okay. So that obligation exists in the HBA. The memorandum, which gets filed in the public record, references the obligation as if fully stated herein, and often advises real estate agents monies may be due and owing at the closing. All right. And so when that gets filed, that's an encumbrance. Now, it doesn't matter if it's a lien because it doesn't let people access their equity. What I'm saying is that they're saying that that appellants are saying that nobody ever proved it was a lien, but appellants' own documents say that it is. And that's what the court considered, and there's competent substantial evidence, and the standard is abuse of discretion, and it should not be disturbed.
One of the questions that came to my mind relating to this issue of a covenant running with land and whether it's an encumbrance. Some title companies apparently did not recognize that it would be an encumbrance preventing some sale of the land. I know opposing counsel referenced 7% of sales. How does that play into this? Because that seems to me to be a question appropriately resolved by experts as to what is the way or proper way to interpret these things.
Yes.
So how is that handled in terms of summary judgment, which is ultimately incorporated here?
Yes. Okay. First, Your Honor, I want to be very clear that the evidence cited by appellant as to the 93% of people who are able to refinance without help from MV Realty, that evidence is not sworn. It is not explained. It is a document dump of 20,000 documents into the circuit court record 3 weeks after the summary judgment order. All right. So the idea that this thing should even be considered at this juncture, it doesn't comply with, the rule of civil procedure 1.510 about giving everything to the court. The other thing is, Your Honor, we don't know that that is necessarily the case. Sometimes title companies don't catch it, but experts, 2 experts, in fact, our title expert, Richard Barbara, he testified, it doesn't matter what you call it. It encumbers property. It is a cloud that has to be removed. Our real estate expert, Richard Fryer, said pretty much the same thing. He said you can slice it or dice it any way you want, but it is not something that anyone would understand, and that it is something that has to be removed before you do a real estate deal.
Did the appellant provide competing?
No, Your Honor. There was no competing experts and no explanation, Your Honor, about title companies treating it any different way. And my suspicion is that the reason, if people were able to refinance without the help of MV Realty, it may be because a title company missed it. It may be because there was a subordination or a lift and replace. There's no way to tell from that late filed evidence, Your Honor, what really happened.
Just for housekeeping, this is late filed evidence, if I can remember correctly, there's a lot of paper here. That evidence came in under your friend on the other side's motion for rehearing. Am I right?
Yes, correct. It was a motion.
The judge treated that as a motion for rehearing, not like a 1.540 or some other evidentiary type.
That's correct.
proceeding. Okay.
Yes, it was in conjunction with a motion for reconsideration, which the judge did here.
One other question that I had relates to the language in the injunction order where it prohibits the following activities related to real property in Florida. This was in the closing section. If has not yet been determined, is there anything that would preclude potentially claims by the appellants for return of the money they paid, or is that? Well, I know that's part of the equitable relief.
That's part of the equitable relief.
But that has not yet been decided.
That has not been decided.
Part of that.
Okay, so that actually that goes to the disgorgement piece of our case, and that will be something that could be asserted as a defense in the disgorgement piece, but more than likely, people, pretty much everybody who got a call got a bad call. They all got calls that violated the telemarketing sales rule. Not all, but many people got them. And so we may try to say that the money that was paid to those people is some type of equitable relief so that we don't have to.
My point is that based on this wording, it seems like where it says following activities to related real property, collecting or attempting to collect any early termination fee or other payment for any alleged breach. So the other payment language is what I'm focusing on. Does this enjoin them from seeking recovery of the $350,
Yes.
$5,000? So
It does, because that's going to be for the disgorgement analysis. Because what they did right before, so after the court entered the summary judgment in September of 2024, we went through the early appeal process and it was dismissed as premature. Then they did motions for rehearing. Then right on the eve of the court entering the injunction, they sent out emails to everyone in the state of Florida offering them to get out of their contracts for a rescission fee equal to what MV had paid them in the first place. They knew that this injunction was coming down. And so we put that language because even after the injunction was entered, they continued to enforce it. They continue to enforce these contracts. And one of the things that they would say is, okay, well, you can pay back the rescission fee. And we didn't want that.
You're at the end of your time.
Am I up to time? That was fast. Yes.
I stood at that podium a long time and it always went really fast. And then I kept talking all the way back to my seat.
Thank you, Your Honor.
So a couple quick points I'd like to just reemphasize. First of all, a great deal of counsel's argument, again, focused on her characterization and assertions about the evidence, what my clients did or didn't do. And again, I would just reiterate the bedrock principle of jurisprudence in not just Florida, but the entire country, that those are facts that should have been resolved by a jury with a trial.
Well, my question as far as they present experts, my recollection when I went through this is there was no opposing expert testimony offered.
And that was my next point, Judge. And the reason for that is that neither of the experts, and I would disagree that Mr. Barbara is an expert, but we never got that far in the case. Neither of the experts have any firsthand experience or even reviewed individual cases. And so we did not think an expert was necessary because when the summary judgment order was,
Motion to strike their experts.
we had not gotten to that point, but
Well, it
most,
seems to me you need to get to that point for purposes of summary judgment.
but they were impeached and would have been cross-examined at trial on the actual evidence of consumer instances. And so the expert, for example, says, well, title companies are going to treat it this way. And then we've got case after case of hard empirical data of the actual consumers themselves. People like Joseph DePrado, Sherry Taylor Clements, Denise Tessier, Marlon Williams, Fabricio Fernandez Ferreira de Silvacio, if I said that right, all of which are cited in our brief, that were the OAG's own cherry-picked consumers that they said have been prevented from accessing equity. And by merely checking the public records, we could show that they were able to refinance their homes without even contacting MV for assistance, which obliterates.
That's established to an evidentiary basis.
I believe it was undisputed. Yes. Yes. It's, yeah.
But you're saying there's information on the public records. That doesn't explain someone's mindset as to why they did this agreement, what they did to, how they managed to get a closing.
What, so I think there are different issues, right? So the mindset, what they understood when they executed an agreement is one piece. Second piece is after the agreement is executed and the memorandum is in place, does the memorandum act as an encumbrance? So opposing counsel wants to say, well, we have these experts that say that it does act as an encumbrance. Categorically, that's how title companies treat it, so they say. But the actual evidence, uncontested, proven by public records, is that these consumers, time and again, when you ask OAG to identify the consumers that illustrate this encumbrance that they've accused us of, time and again, the evidence falls short and it does not actually prove the assertion that they've made. And so you see a litany, and this was all evidence that was in the record prior to summary judgment. So we added then with the motion we consider after, but showing the specific consumers, the 28 consumers that OAG identified in their sworn interrogatory as illustrating their claim that consumers were prevented by the memorandum from accessing equity, that the memorandum acted as an encumbrance, when in fact you look at the public records, those consumers that the OAG cherry-picked don't actually prove their case. And in fact, on cross-examination at the evidentiary hearing, OAG's lead investigator, Ms. Rossi, admitted several times that she failed to even check the public records to see if these consumers had in fact been prevented from refinancing their homes, and they had not. And so that was why we did not have an expert, is because we had hard evidence that showed that the experts were dead wrong. They were just wrong. They were, like many experts, they were paid to give an opinion. They had I will also say Mr. Barbara is an industry person who has pretty significant bias. And these were all points that we would have drawn out on cross-examination, as the saying goes, which is the greatest engine for the discovery of truth. And that's what we were counting on. And when the summary judgment opinion happened, we thought we were several weeks from trial. We were set for a trial period in October. It caught us by surprise. And we had a fair amount of the evidence that has been characterized probably fairly as a data dump, but showing that the massive, overwhelming public record evidence in Florida shows that their core allegation about the memorandum just isn't true.
Well, let's come back. You said that you were surprised by this summary. These were cross motions for summary judgment, were they not?
They were.
So you had your evidence.
Correct.
They had their evidence.
Correct.
Are you suggesting that the evidence wasn't disclosed as it should have been pursuant to the rules?
No,
That hasn't been raised.
what I would say is,
It was a product.
I would say the result with respect to the finding
When the judge ruled in favor of
That-
the state.
that close to trial, the summary judgment ruling that the memorandum, that it's undisputed, I think is the language from the summary judgment order, that it's undisputed that it acts as an encumbrance, shocked us. Given the way the evidentiary hearing unfolded, given the evidence that we had put together in the summary judgment paper, that their own consumer examples did not prove the proposition or the assertion that they were claiming. That's what surprised us.
Just about whether these agreements were encumbrances on the title, correct?
Agreed, there's more. Yeah.
There's more. There's like, these people signed a document that gave your company the right to 3% of the value of the property based on any transfer, correct?
No, not based on any transfer. There are exceptions spelled out in the agreement, and the purpose of the
Yes.
estate planning, transferring to heirs is one. Refinancing, for example, is another. And so if I may step back, I think the best way to illustrate the point, Judge, the core bargain here that MV pays a consumer for the right to be their agent, which is a right that historically consumers have given away for free. There's no contention that that is, and there's no finding that that core bargain is unconscionable, right? So the question then becomes, is the manner in which it was implemented in this case through this program unconscionable, both procedurally and substantively? Because as Judge Labbert pointed out, both have to be established. I agree with Judge Labbert that procedurally, the determination whether it's procedural unconscionability depends on a host of disputed facts. Regarding substantive unconscionability, again, the core bargain was not found to be unconscionable, and I don't believe that the OAG has claimed that it is. And what you're then really talking about is a dichotomy between consumers who breached the agreement, they breached the core bargain by never giving MV a fair chance to be their agent, and then people who have, which is a very small minority of cases, who may have paid a termination fee in what I'll call non-breach situations. And we offered to stipulate that we would stop and we would not ever collect termination fees in non-breach situations. That stipulation was not accepted by the court, but then even still, we would argue that even if some injunction is appropriate pending a full and final judgment, that would be a more appropriate scope of the injunction at the very least, because that is the alleged harm that is supposedly so bad that even though it is a rare amount of circumstances, if consumers understand the core bargain that they were receiving this payment to give MV the right or the option to be their agent, that they would breach the agreement. And I don't think.
Let's clarify, when we talk about unconscionability of the contract, procedural, substantive, that has to do with whether the contract is enforceable or is indeed a contract, correct?
Correct.
But here we're talking, and for that, everybody, one of the questions is whether the transaction or the behavior violates the standards of unfairness and deception set forth and interpreted by the FTC or federal courts is one example. That doesn't have to do with whether the contract is unconscionable in the traditional sense of enforceability of the contract, correct? That has to do with whether the behavior that caused the party to enter into the contract violates the or the standards of unfairness.
I guess, Your Honor, I believe that they're really one and the same, even if
Are they?
I believe that they are, and that they would still have to establish both procedural and substantive unconscionability, and on substantive unconscionability, that it shocks the conscience, it's monstrously unfair. For example, I think it's the Januski case that references that language. And indeed, the summary judgment opinion by the circuit court, which of course then the injunction order is based on, goes through these procedural and substantive. So I would argue that Judge Forfante also thought that he had to make findings on both procedural and substantive unconscionability in order to render the contract unenforceable under FDUCTA. Yeah, right. Tomato.
Impact is a verb also about this. Well,
Okay,
well, about 45 seconds.
again, I just would reiterate, Your Honors, that there are too many disputed facts to justify the imposition of the injunction, even separate apart from the summary judgment ruling. You're talking about an innovative Florida business that was wildly popular. In a very short period of time, over 9,000 Floridians eagerly signed up for it. My client didn't even have the capital to fund as much demand as there was for this product. They worked hard to try and do it lawfully. Everything was disclosed in both the agreement and the training. And to have this kind of sweeping injunction that has destroyed the business, threatens to destroy the lives of the individual defendants, there at least ought to be a trial. And we should be given the opportunity to cross-examine their experts, their witnesses, to hear from the consumers themselves, including the consumers like DeVaris Clark, who we reference in our brief, who liked the product. And in fact, when the program worked the way it's supposed to, are better off with more money in their pocket than the traditional real estate model. Thank you.
Thank you.
Thank you.
Interesting.
Been an adventure, right,
Yes.
counsel?